In a shocking move, the Duncan v. Bonta California magazine ban case has been taken en banc in the Ninth Circuit immediately. This has huge ramifications for a fast Supreme Court review of this case, and we also got some dissenting opinions from the judges in the Ninth Circuit who called out their colleagues for being corrupt and essentially affecting this case in a way where it should have been ended back in 2020. So let's talk about this. But real quick before we jump into this video, if you think magazine bans are clearly unconstitutional, go ahead and hit that like button and subscribe. Also want to mention that the Route 66 Shooting Sports Park event is coming up. The Range Expo is coming up this upcoming weekend, October 7th and 8th. You can RSVP using the links down below that I'm going to put in the description section and also in the pinned comment. Myself, Reno May, Mike Glover are going to be attending as guests. It's always a ton of fun, so check it out. I hope you guys come out. I would love to see you there. And again, you can check them out using the link down below. As I mentioned in the intro, in this video, we're going to be breaking down some huge news that dropped, which is coming out of the Ninth Circuit. And the Ninth Circuit has decided to essentially fudge some of their rules and take the Duncan v. Bonta California magazine ban case en banc immediately. This is an unprecedented move by the Ninth Circuit and shows how the Ninth Circuit is still dedicated to violating the Second Amendment and the Supreme Court's recent Bruin decision. The Ninth Circuit issued an order that they are going to take the Duncan case as a comeback case, and this has huge implications not just for California, but other states that have magazine bans in the Ninth Circuit like Washington and Oregon. Now, for those not aware, Duncan v. Bonta involves the California ban on the possession and purchase of magazines that hold more than 10 rounds. This law was challenged, and a district court judge, Roger T. Benitez, issued his original order, finding that the law was a violation of the Second Amendment. Now, on review, a 3-judge panel in the Ninth Circuit reviewed the decision of Judge Benitez and agreed with him. Then the case was sent to the Ninth Circuit en banc panel for an appeal. And on review, the Ninth Circuit en banc panel ruled in favor of the state of California. That decision by the Ninth Circuit en banc panel was then appealed up to the Supreme Court. The Supreme Court decided to grant, vacate, and remand the Duncan case back down to the Ninth Circuit, the en banc panel, for them to reconsider the case in light of Bruin. Now, at that time, the Ninth Circuit en banc panel and the 3-judge panel also decided to not want to take up this case. They did not want to reevaluate this issue, so they decided to punt the case all the way back down to Judge Benitez. So the case was sent back down to Judge Benitez, and last week, Judge Benitez once again released a decision, and he struck down the California magazine ban. Now, in the same order, he also granted a 10-day stay on his own order so that the state of California could seek an appeal from the Ninth Circuit, and the state of California did seek an appeal in the Ninth Circuit. Now, that stay from Judge Benitez was supposed to end on October 2nd, so the question is, what was going to happen? What was the Ninth Circuit going to do? My anticipation with a lot of other people was that the Ninth Circuit was going to grant some sort of stay and that we wouldn't get a Freedom Week. Now, there was a huge curveball that was just thrown in this entire case. Instead, the Ninth Circuit en banc panel, the same panel that heard the Duncan case before, has stepped in and has taken control of this case. The Ninth Circuit en banc panel claims that under their rules, they can take this case Duncan as a comeback case and rehear and decide this emergency motion on their own. In doing that, the en banc panel also issued an extension of the stay, which was issued by Judge Benitez. And right now, that 10-day administrative stay, or the administrative stay, is essentially going to last until October 10th. So from the outset, I will say this means that we're likely not going to get a Freedom Week. I told you guys it was a long shot going into this, and now that the Ninth Circuit en banc panel has stepped in, it's very, very unlikely that anything positive will result from that panel. But there is a huge silver lining with what just happened. This means that the Duncan case was just fast-tracked through the process. It likely means that we're going to get Supreme Court review of this case faster than we thought. But here is where things get really interesting. There was a concurrence by Judge Hurwitz and then 2 dissents. In their dissents, Judge Bumate and Van Dyke go after the Ninth Circuit because they are saying that this Ninth Circuit en banc panel is just trying to meet their ultimate agenda, which is to violate the Second Amendment and defy the Supreme Court. Now, Judge Hurwitz, in his concurrence, claims that all the Ninth Circuit is doing right now is granting an administrative stay until October 10th, and essentially he tells Judge Bumate and Van Dyke that they need to chill out. All these dissenting judges need to chill out. Nothing crazy is happening right now. But we got some interesting information out of Judge Bumate and Van Dyke. Bumate, in his dissent, states that for over a decade, our court has improperly interest balanced our way around the Second Amendment. The Supreme Court has had enough of it. In Bruin, the Supreme Court made clear that the Second Amendment must no longer be deemed a disfavored right. With this clear direction from the Supreme Court, you might think that our court would return to regular order and handle this Second Amendment case like all other before our court. And in the normal course, emergency motions would be handled by a 3-judge panel. But not here. Because this is a Second Amendment case, we now take the unprecedented step of taking an emergency motion as an en banc panel in the first instance. While our rules may leave room for such an unusual step, discretion and wisdom counsel against it. Indeed, to my knowledge, no en banc panel of this court has ever handled an emergency administrative stay motion as an initial matter, and the majority cites no precedent otherwise. And then he states, so I'm left wondering why we rushed to do something so unorthodox. So in his dissent, Judge Bumate respectfully calls out the court, essentially saying that we and the public all know what they're doing. They're bending the rules because they want control of this case and they don't want a pro to a decision. But then Judge Van Dyke goes in his dissent and absolutely dismantles the colleagues in the Ninth Circuit, calling them out for the corruption that they're really engaging in. Judge Van Dyke states in his dissent that I share Judge Bumate's concerns about the irregularities created by the en banc panel's all too predictable haste to again rule against the Second Amendment. Apparently, even summary reversal by the Supreme Court has not tempered the majority's zeal to grab this case as a comeback, stay the district court's decision, and make sure they, not the original 3-judge panel, get to decide the emergency motion, and ultimately the eventual merits question in favor of the government. I think it's clear enough to everyone that a majority of this en banc panel will relinquish control of this case only when it's pried from their cold, dead fingers. And I think it's clear enough to everyone why. But then he goes on to give us information that no one knew before, and it's kind of coming to light for the first time. He states that, but the current irregularities highlighted by Judge Bumate's dissent are not the only ways that this case continues to demonstrate our court's enduring bellicosity towards the Second Amendment. The irregularities in this case run much deeper, indeed, all the way back to when this case was first called en banc. This en banc panel was born in illegitimacy, and this case should never have been taken en banc in the first place. After the 3-judge panel first issued its opinion in August of 2020, one judge on our court requested Rule 5.4b notice in 3 cases, including this one, but then inadvertently missed the deadlines to timely call the cases en banc under our clear rules. That could have happened to any judge, he states, but rather than simply accepting the result dictated by our rules, or even deciding as an entire court to waive our rules, we went in a different direction. First, the decision was made by someone, not by the rules or even the entire court, to allow the respective panels to waive the deadlines on behalf of the entire court. Then the campaign started. Earnest conversations were had, hearts were poured out, tears were shed, and pressure was applied to the panels with mace-like collegiality. And in the end, a discrete collection of judges, again, not the entire court, struck a compromise, circumvented our own rules, and allowed the en banc call to move forward. In sum, he states, not only is our court treating this case special now, but the process that brought this case en banc in the first place was illegitimate from the start. He then concludes by saying, the story of the Second Amendment in this circuit has been a consistent tale of our court versus the Supreme Court and the Constitution. That tale continues today and will continue as long as a number of my colleagues retain the discretion to twist the law and procedures to reach their desired conclusion. So let that really sink in. What we just found out from Judge Van Dyke in his dissent is that back in 2020, this case probably should have never made its way to the en banc panel. This case should have died back in 2020. Now, I remember back in 2020 here on the channel, we covered that. We covered the 3-judge panel's decision. We covered how potentially this was going to go en banc. We even covered them missing the deadline. And then we saw that it still went to the en banc panel for review. And I know back then, a lot of us were confused kind of how that happened, but we kind of had to glaze over it because the en banc panel took the case. We assumed that maybe something happened, and now we found out really what happened. We just got the answer. It was corruption. So things are really getting interesting in the Duncan case. We likely won't get a Freedom Week. Again, I want to make that very clear, especially since this is in the hands of the Ninth Circuit en banc panel who's ruled against us in the past. But this case is likely going to be years ahead of where it probably would have been if this would have went to the 3-judge panel, and this likely means that it's going to find its way before the Supreme Court sooner rather than later. As we get more information, if we get any other updates, anything else develops, I will let you guys know. Also, if you like this video and like support the channel, one of the best ways to do that and the free way to do that is to just simply like, comment, and subscribe. I want to mention that about like 60% of my viewers right now are not even subscribed to the channel, so please consider subscribing to the channel. And when you do subscribe to the channel, or if you're currently subscribed to the channel, make sure you click the notification bell, click on all notifications, because that will help to actually get you the information. Sometimes YouTube plays some weird games and you guys won't get these videos. So make sure you have that all on. And also just subscribing to the channel and supporting the channel triggers the algorithm and lets it know that people are interested in this topic, interested in these videos, and then it also pushes out to more people. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.